All righty. Well, welcome everybody. Let's get started. Can you hear me okay? All right. Happy July. Welcome to our July meeting of the LA Multifamily Meetup. As you know, we meet every month and we have different speakers addressing issues that affect multifamily investing or investing in real estate in general. So stay tuned for a lot of exciting classes we have coming up. For example, next month, we have a course on ADUs and a little bit of updates with, I think, SB 9. We have Brickwork LA coming in, who's going to give us all the updates on how you can add value to your multifamily units or single family homes through ADUs. So that'll be next week. All of our classes are on our YouTube page, so we invite you to go to The Collective Realty on YouTube and take a look at a lot of our past courses. If you need slides on any of the presentations, let me know and I can always get that to you too. But at The Collective, our mission is really to create paths to wealth through real estate. And a lot of the creating paths to wealth has to do with education. So we've always been really passionate about putting on education for our agents and for our clients and for our future clients. So everyone's welcome, whether you're an agent at The Collective or not. You're always welcome to attend our education and hopefully learn something and help us improve the service we can all give to our clients in this real estate industry. So I guess I would love for us to just go around the Zoom room first and everyone just introduce themselves, say hello, who you are, and if there's anything that kind of brought you to this course today or anything you're looking for or interested in a couple sentences, that would be good. We just would love to know who we have as part of our group today. So RJ, you're the first one I think to log in. Why don't we start with you?
Hi, I'm RJ. I have a business here in Santa Monica Boulevard in West Hollywood, my 12-step store. I purchased a condo last year and I purchased it in my name, but I wanted to transfer it to a trust. So when I saw this email, I was interested in learning more about it, as well as some future investments that I possibly may inherit. What is the best route to keep those in my name and or to create a trust?
Great. Yes, perfect. Today's session is all about estate planning, and it's one of the easiest and most important things you can do when you become a property owner. So you're in the right place. Betsy. Hi, Betsy.
Hi, good afternoon. I'm Betsy Hall. I live in Silver Lake. I've worked with Wiltau and I've worked with The Collective in the past, so known you for years. If I could, I'd love to put in the chat a vision board workshop that I'm doing at Say Cheese tomorrow. It's a wine tasting and vision board, and I think that ties in integrally with our visions for the future and for future generations. So
absolutely. Please, everyone, use the chat as much as you'd like to greet each other, to promote any listings, to promote any events coming up. Part of the session is about networking. So before COVID, these were only in person and things have changed. So now it's a little mix and usually a little bit more heavier on Zoom and a little harder to network. So use the chats for sure to try to network and build relationships. Christopher, welcome back.
Yeah, I would share a little bit about why I'm here today, if I could, for one.
Yeah, please.
Yeah, because I have heard a presentation with you all before about estate planning, and it was so important information I hadn't heard from any other place. And I'm going through a divorce, and I live with my 89-year-old dad in his house. So I'm concerned about tax consequences and best practices for documentation. Thanks.
Good. Christopher.
Hi, Anthony and everybody else. Thanks for having me today. And Anthony, thanks for your email for the invite to be here. I'm a real estate agent with Engel and Volkers in the Beverly Hills office. The office is right on Camden over there. And I came to real estate through investing. I grew up in a family that invested, and so I myself am invested. And so I always like to look for a way to protect assets. So I'm here to. We have our stuff held, so our stuff is held in LLCs and trusts already, but you can never have enough information. I'm a real information kind of guy.
Yeah, absolutely. And things do change from time to time, and it's definitely important to always stay up to date. So glad you're here, Chris.
Thank you. Thank you.
David, Mr. Eichmann, hello. Are you up on Sunset?
I am in Mammoth Lakes today, which is why the internet is a little sketchy, so I can't do video. But I am a local West Hollywood-based real estate and business formation attorney. Thank you, Anthony, for putting these on. And as Christopher said, we can always learn something. And even though I'm an attorney, I don't practice in the estate planning department that's highly specialized. So I need to be able to know who I can refer clients to. And that's why these educational forums are so valuable. So thank you again, Anthony.
Yeah, my pleasure. Thanks for being here, David. And feel free to put your info and specifically more of like what you do. So if someone needs your services, they know who to reach out to as well.
Great, thanks.
Amy, are you able to unmute and say hello?
Hi, everyone. I'm Amy Braun from Fresno, California. I have been a realtor for 9 years, and I am very interested in purchasing. Right now, I'm just purchasing single family residences. And, you know, my goal, of course, is to start doing multifamilies. And I'm also working on a trust right now. And so I thought I really appreciate the invite. And so thank you for that. And I look forward to hearing what you all have to say.
Great. Thanks, Amy. Glad you're here. Kristen and Matt, and then MNL.
Hi, this is Matt, and I'm in the car with not only Kristen, but our 2-year-old and 4-year-old. We're just looking to learn a little bit. We have units in Santa Monica, and we're trying to figure out how to expand beyond just our units there and see if we can diversify our portfolio. You never, like you said, you never know what changes, and municipalities change rules, et cetera, that could have impacts on our portfolio. We'd like to maybe broaden our portfolio a little bit.
And we're heading.
Yeah, very good, very good. Glad you're here. Every month we have different ways and opportunities to do that, and some great lenders and mortgage brokers and people that are doing creative things to help us kind of expand. So I'm glad you're here. ML? How about Diana, or no, Dina Perez?
Hi, I'm Dina from El Paso, Texas, not from California, but I'm here basically just to learn. I saw the email come through, and my prior career to this was a funeral director, embalmer, mortician rather, for a number of years. And so estate planning, I've got several clients from the funeral industry that have that I'm interested in helping further. I know Texas is a little bit different, but it's just gathering as much information as I can. And like I said, I saw the email come through, and here I am.
Great, great. Welcome. Ellen, and then Nick. Ellen. All right. How about Nick? I know you've been here before. Ellen, hey, I saw you on mute.
Oh, okay. Hi, this is Ellen. I'm from the San Francisco Bay Area, and I am overseeing a family trust, and I'm also a client of Will Tell. So I'm here to learn more about the estate planning and also any updates on law changes, etc. Thank you for inviting me.
Welcome back, Ellen.
Thank you.
Diana Wong. Diana, I saw you on mute. Don't hear you. Okay, Patricia Carroll. Longtime LA realtor.
Hi. Yeah, why am I on this call? I just was really curious to hear what you guys had to say. And I also wondered if you were going to be addressing Prop 19, which I'm still reeling over, although I know it was realtor supported. But yeah, I'm just really interested.
Okay. I don't know if we're going to talk much about Prop 19 today. Might want to touch on it at the end, but trying to think, we did address that recently. So if I find any information on it, that's the most recent, I can get that to you. Farnaz, hello. Would you like to just introduce yourself or let us know what brought you here today?
I'd like to introduce myself. I'm an advisor, investor with Shore Capital Corp. And I've been a real estate agent for past 9 years.
Great, welcome.
Thank you.
All right, well, I'm going to turn it over now to the director of our commercial multifamily division, Will Tiao, who's an investor himself, has owned a huge property management company, and is an amazing realtor and friend. So Will, take it over for a minute.
I'd love to. Do we want to let you guys in the room introduce yourself?
Oh yeah, well, we have our speakers. Let's, Miss Mary, would you like to say hello?
Hi, my name is Mary Allen. I'm a realtor with the collective, and I am here because I believe in multifamily housing as an investment vehicle, and always interested to learn more. Thank you.
Great, and we have an amazing title rep, my favorite, Miss Zoe.
Hello, everybody. I'm Zoe Schulman with WFG Title. I've been working with Anthony since he started in this business. I have quite a bit of experience, and I brought with me a guest speaker, Ernie Pollard, who is our Chief Title Officer. And she's going to be here to answer questions and give some more insight in terms of what a title company looks for regarding trusts and probates.
Right.
Okay, great. And we have also Hee Jae here, who will introduce in just a few minutes. A wonderful attorney to talk about our estate planning for today. So, Will, go ahead.
Okay. Thanks, Anthony. And great to see everybody. Great to see a good turnout. You know, like Anthony said, this is a super important topic. So I'm really excited to get into the nuts and bolts of this. So we always take a few minutes to go over kind of what the temperature of the multifamily market is right now, as well as give people a chance to go over like any listings that they have, and any needs, deals, and wants they want to discuss. So in terms of the temperature of the market, you know, I think the multifamily market, you know, is not unsimilar to the residential side in that it's been very affected by the interest rates. You know, transactions have slowed down tremendously. A lot of people have, you know, locked in lower interest rates. And so they're not, you know, very keen on selling unless, you know, there's a particular need to, or they see a particular investment opportunity that they'd like to maybe do a 1031 exchange in. If you have any questions about 1031 exchanges, we've had a lot of different seminars on that on our website, as Anthony has mentioned, and happy to discuss that with you. But it's basically a way for people to sell investment real estate assets and defer the capital gain tax payments. So anyways, yeah, so it's still pretty slow. There's not a lot of inventory on the market right now. And we're definitely seeing price cuts, price adjustments, you know, on a number of things. And that started pretty much since last May, when the Fed started increasing interest rates. And, you know, as we all know, you know, interest rates have pretty much doubled or even a little bit more in some cases in the meantime. And so that's obviously changed people's numbers when it comes to investing, and everybody's kind of still adjusting to the new reality of what the numbers look like. And that's affected cap rates. Cap rates have definitely gone up. And, we're still seeing a number of folks kind of still, the COVID moratorium per se is no longer in effect, but there are still kind of, residue things. I was actually just right before we got on the call. I was on a call with a UD lawyer, unlawful detainer lawyer, because we're actually going to go into unlawful detainer court tomorrow to go through an eviction of a tenant. And this tenant has not paid for 5 months. Basically the lawyer told me, oh, you're lucky. You're only like 10K in arrears. I have clients who have tenants who are 200K in arrears, so, and 30K in arrears, 50K in arrears, so those types of situations are still out there and outstanding. So, it's the constant, moving target in this multifamily world. But let me share with you some of the listings we have. Some of them are kind of interesting and unique. So this one is this is a single family a house in West Hollywood on the corner of Stanley and Romaine. And for those of you who are realtors in the room, which it sounds like most of you are, I think so this is a 1,900 square foot house, 4-bedroom, 3-bath, open concept, completely renovated. And, when we comp this, most single family houses in the area are closer to 1.6 or above. As you can see, this price is at 1.345. So the question is, why is it priced this way? And the reason it is because this is a tenant in common property, a TIC. And this is something we specialize in, which is taking kind of multifamily units and converting their use into tenants in common so that you have shared ownership of the property. In this case, this single family house, which is detached from, there's 2 more units on the property, 2 1-bedroom units and a garage. And in this case, the owner is planning to keep the 1-bedroom units and the garage, and then eventually we'll sell each of those off as a separate tenant in common, including the garage, because as we all know, you can now turn, often garage spaces into ADU spaces. So, because it's in a shared ownership scenario in a TIC, and because of the type of financing that you would need for a TIC, there are limited number of lenders who do this. So to take compensation for the risk, the owner has decided to price it, with a pretty healthy discount. So there is an HOA. The HOA includes the insurance and the property tax for the property. There is one property tax bill for the entire property. So the property tax here would be shared. And in this case, the owner is actually going to be subsidizing some of the property tax amount on here. So it's an interesting property. If there's any interest for any of the agents in the room, if you have any clients who are interested, please let me know. We're doing this kind of by appointment only. And I'll put all this in the chat, so if anybody has it. Can you all see the next one, the one on Pico? Yep. Okay, so this is a commercial building on Pico and Fairfax. It's a production studio currently. So the bottom floor is like 3,900 square feet. And then there's an additional 1,100 square foot space upstairs. The 3,900 square foot is currently vacant. It's owner occupied. It's a studio space. They use it for photo shoots and video shoots. You can kind of see like pictures of the high ceilings here and whatnot. It's 2-story ceilings. They've got recording studios. They got makeup and fitting rooms. The upstairs 1,100 square foot space is a private gym. And it's a little over 5,000 square feet. We just did a price reduction to 2299. That puts it at 5.32 cap. And comes with 4 parking spaces. And it's kind of perfect for owner user. So you can, a lot of people are looking at this and thinking about using SBA financing, which would allow you to put as little as 10% down. So we're getting quite a few calls from potential owner users here. We're getting a lot of people who are thinking about converting the space, talking to folks who are thinking about like maybe turning to offices or whatnot. But it's kind of an interesting and unique space. So one thing we also do here, if you have any questions, once again, let me know. I'll put this again in the chat. So one of the things we do here is we often talk about off-market properties, properties that are not yet on the market or coming soon. So this is one of those. This is a Burbank small office building, about 3,300 square feet. It's fully renovated. It's basically, it's 2 offices. There's one that's about 2,200 square feet and one that's 1,100 square feet. The 1,100 square foot space is already rented at 3,300. So that's over $3 a square foot. The 2,200 square foot space, which is the space you're looking at right here, is currently vacant, ready for an owner user. Once again, this is a perfect property for SBA financing. It's got 4 private offices, 4 individual private offices. You could put 1 or 2 people in each of those offices, and then 2 kind of larger offices that could put 4 or 5 people in there, a conference room, a main room in the middle. This is the lease space right now. It's kind of just open concept. And the original use was going to be like a co-working space, a la kind of like a WeWork situation. So we are in the process of putting this on the market. Full disclosure, I'm a half owner in this building. So we are in the process of getting ready to put this on the market. So we're going to list it at 2,499. Let me see. Oh, one last thing I want to make sure for those of you who do own multifamily rental properties in the city of Los Angeles, this is very critical. This new ordinance, which was approved by the city council, says that you must put this ordinance, the city of Los Angeles renter protections notice, on your property, on the property that you own and or manage. It needs to be like kind of framed and put up there for the tenants to be able to see. And if you don't, that's a violation of the rent stabilization ordinance, and you can be fined for it. So I would highly suggest that all of you who are owners of multifamily properties in the city of Los Angeles get a copy of this notice. I can send it to you if you need it. And once again, I can put this in the chat as well. So that is pretty much it on my end. We usually open things up right now to talk about needs, deals, and wants. If there's anybody who has a need, a deal, or a want that they're interested in, this is now a great time to discuss.
I'll share one thing I just put in the chat website for a triplex in Silver Lake. We had it on the market for a few months, went into multiples randomly, like after it's been on the market, went into escrow for the last few weeks, and it just fell out of escrow, unfortunately. So it's back on the market. It's listed at 1.95. It's 3 units. There's a front house, so it'd be amazing for an owner user to live in the front house, 2-bedroom front house. And then there's 2 1-bedrooms in a back building that are getting $3,000 a month rent. So the income is really great. Plus you can convert, there's a couple opportunities to convert an existing space to another unit. You can convert the garage to an ADU, and you could do another ground up build if you wanted to. So up to 3 more units could be added. It's 837 Mitchell Trena. All the floor plans, videos, everything's in the website. So would love for you to check it out and pass it along.
Very good. Are there any other needs, deals, and wants?
I have something. Yeah, this is Mary again. And It's not multifamily, but what I'm looking for is a fix and flip house, single family home. Multifamily would be okay if that's the right deal, but in the LA area or Ventura County for around the 500, 600K mark. And I'm seeing most of these properties that are going before they get to market, or else I get priced out. So any insider information, I'd be very grateful. And what I have also is a off-market listing for a single family home in Benedict Canyon. It's a 2-bedroom, 1 bath. They're asking 1.6 million.
Great. Thank you, Mary. Anybody else?
Hello.
Hi.
Hi. I have a 1031 exchange from Las Vegas to Los Angeles. The property is worth about between 715 to 730. If you know of any cash buyer who want to invest into Vegas, and also they are willing to do exchange for a multi-unit in LA. So the multi-unit must have a tenant and income to qualify for loan.
And how much, what price range are they looking at in?
They're gonna put that the whole amount as an exchange and borrow against it. Borrow, get a loan. I know the rates are high right now, but they can always refinance later when rates come down.
So they would put down, you're saying like 730 to 750, and then
750 to 730 would be put down, and the rest would be a loan.
the rest would be a loan. Okay.
Yeah, but the property should have an income to qualify.
Got it. Okay. So let's say they put 50% down, then they were talking about 1.5 million if they put 50% down. Yes.
Yeah. Yeah.
Okay. And at 50% down. Okay.
Yeah.
And is there a particular area that they're interested in?
Somewhere with high energy of renters. I mean, good tenants, and if the property is market rate rented, they'll be fine with it.
Okay. All right.
It's kind of complicated, but it's doable.
Sure.
Okay. Thank you.
Thank you. Anyone else? All right. Well, then I will hand it back to you, Anthony, to introduce our speakers.
All right. Thank you. Well, so our first speaker today is an attorney. His name is Hee Jae, and we're going to talk about estate planning. He has a whole wonderful presentation prepared for us. I've known Hee Jae for a little while, and he's one of the very, very smartest, sweetest people. And I'm excited that he's here for you all to get to meet today as well. So welcome. Let me get the screen shared for you. All right, can you guys see the slides? And then just tell me when to go to the next slide. So it loads.
Yes.
So my name is attorney Hee Jae Yoon. There's a QR code up there. I'm an estate planning attorney. You can actually use that QR code. It'll take you to a link that's going to show 3 links. One is to the firm's website. The other is to my Calendly link, so you can actually schedule a free consult. So everyone who's here today, I'm offering a free consult. So if you have any estate planning questions or needs, you can schedule that consult on any free available slots. The other is a link to register to a weekly webinar I hold. I do a overview of estate planning for about an hour-long webinar. That's every Wednesday at 11 a.m. Western time. And so you can just log on, register for that, and just listen when you want to. Or you can, if you have clients, for those of you guys are agents that wants to learn something, it's another service you can offer them, saying, hey, I can get you a free consult with an attorney, and you can use the links and whatnot. Go to the next slide.
Okay.
We can actually skip this one. Okay, so for estate planning, one of the first things you need to do is you have to know the rules, both for when you're alive and after your death. So if you're doing estate planning properly, it's not only about protecting the assets of your death, it's also protecting your assets while you're alive. So we'll start with the rules for when you're alive. So most of you guys are healthy, and so you never really think about this. Come to the next slide. But what happens if, because when you're healthy, competent, you control all your assets. But have you thought about what would happen if you were to end up in a prolonged coma? Or it's later in life and you have dementia and you don't know what you're doing? Who controls your assets then? Now, for those of you that might be investing in your personal name, if it's only in your name and something happens, your wife, your spouse, or husband, either way, or even if you don't have any spouses, but you have children, they actually cannot control your assets automatically. You actually, if you don't have something in place, which unfortunately is most people, you end up having to go to probate court, and the court's going to appoint 4 different types of people right off the bat. They will appoint a guardian, since you don't know what you're doing, to handle your day-to-day affairs. They'll appoint a conservator to manage the assets. They will also appoint an attorney for you to make your legal decisions. And then they have to appoint a doctor to determine your competency. Now, if that happens and you're in probate court, you will be responsible for paying for the cost of all those people that the court appointed. Now, here's the thing that most people don't seem to understand. The court is not required to appoint a family member as your conservator, even if you have one. The court can appoint anybody it wants for the rest of that person's life. Okay, so this is about during your own lifetime. Now, some of you think, well, I've done my power of attorney, so I'm good, right? Maybe. The question is a maybe. The reason is there are different types of power of attorney, and so you want to make certain you have the right one, because if you don't have one that deals with maybe incompetence, your power of attorney doesn't mean anything if it doesn't address that part. Now, if you have the right one, it won't always go smoothly, especially when it comes to like properties and businesses, because if they have debt and whatnot, the banks won't always support you. The reason for that is because the power of attorney is actually abused a lot. And most people who are under this power of attorney who have done it don't understand they're being taken advantage of, because if you think about it, when the power of attorney comes into effect for a lot of these people, they don't know what's going on, so they don't know that they're being taken advantage of. Now, so you have to have the right one, and you want to make certain that the right one has the right protection, particularly if you're appointing someone who's not your spouse. Because with the generic financial power of attorney that people find online or whatnot, the person that they name can do anything they want with your assets. That includes withdrawing all the money out of your own account and putting it in their own personal accounts. And we've seen it happen many times. Now, if you have the right ones with the right protections and something like that happens, and someone finds out about it later, whether it's you because you regained competence or your family member, you can at least go after the banks if they still allowed that to happen, because you had the right protection. The bank should have stopped that. Okay, so that's the other thing. The other part of it is making your healthcare decisions, the healthcare proxy, the living will. Now, a lot of people just do this, on the fly and whatnot, but it doesn't really help anyone because, like, particularly the living will, that is misnamed because people think, oh, when they hear the living will, a lot of people think, oh, that's my will, right? Actually, the living will is where you're making your end of life decisions regarding your healthcare. So if you have terminal condition or you're in a permanent vegetative state, you're saying, what kind of life support system do you want them to do? And so for these kind of things, you want to put your thought into it so that when if something like this arises, your family knows what you want when it comes to your healthcare decisions. Because if you leave it vague, guess what happens? All your family members are going to start arguing with each other. They're all going to think that they're right. And so that becomes an issue. So when you're doing these things, please put some thought into it. Now, if we go to the next slide. Now, what are the rules after death though? For most people, they end up in what we call the no will category. That might be most of you if you haven't done any sort of estate plan. Can we go to the next slide? Now, if you're in the no will category, that the probate court has to step in and take control over those assets. Now, particularly in California, how you title the property, even among spouses, will determine whether the probate's necessary after the first spouse dies or only after both of them passes. Now, California allows, there's 4 different titles generally when there's multiple people. There's tenants in common, in which case, anytime somebody who's listed on that deed dies, the property technically has to go to probate. There's a joint tenancy, and if it's a true joint tenancy, then the last person surviving takes the whole property, and when that last person dies, it goes into probate. Now, for married couples, there's 2 different types of way you can do it too. There's community property, in which case, when one spouse dies, that property technically has to go through probate. And there's community property with right of survivorship. And if it's right of survivorship, it automatically passes to the surviving spouse. And when the second spouse dies, it goes to probate. Now, people find out, you hear about married couples, they go, well, one spouse died, we never had to do probate. Generally, that's because they continue residing there, and that's not really an issue generally. It just makes the probate much more difficult when the second spouse dies, because technically the first probate should have been open when the first spouse died. And now the court has to now backtrack through years of financial transactions to determine what should or should not have been done. And that makes it more expensive when the second spouse dies. Now, so when you have no as I said, the probate court steps in. Everything's public. If you're having to go to probate, everything's public, meaning anyone can find out what you own, how much it's worth, who you owe money to, how much you owe them, and where your assets are going. Now, if you're wondering why newspapers were reporting everything about Prince's estate, it's because he died without a will and they were going through probate. And when we say assets are frozen, that means if you have no will and you're a spouse, say you're a housewife, and the breadwinner was the one who passed away, and you need access to the asset just for your maintenance, you actually have to petition the probate court for spousal support to be able to gain access to any of the assets. This process will take, on average, a minimum of 1 to 2 years. That's the minimum. It can take longer. It'll also cost anywhere from 5 to 20% of the value of assets. Now, it can also be more expensive. Those are what I put up there is the average. It'll take longer. It'll be more costly if anyone's fighting over the assets in probate court. And that's what happened with Prince. That's why his probate just finished at the end of last year, because people were fighting over the assets. Now, for those of you that might have property outside the state of California, I know most of you guys are from California, keep in mind, every other state you go into and you don't have a will, you've just multiplied your probate, because you actually have to go through this process in every single state that you own assets. And if you think about it, if you don't have a will, you have zero control over who's receiving your assets. The surviving spouse may only get a third to half of the assets. Now, for those of you that have minor children, the probate court holds on to those assets and manages those assets until they turn 18, at which point they just turn over one lump sum. Okay, and none of those assets can be touched for those minor children while they're still minors. Now, that's the situation most people find themselves in. Now, can we go to the next slide? There's some of you that are thinking, well, I did my will, so I'm good, right? Well, that's unfortunately, while you have a will, the process, it doesn't change at all. You see, you watch movies, you watch TV shows. What usually happens when someone passes away in those shows? The family attorney calls the family in for will reading. There's a will reading, and then everyone seems to go on their merry way with the property as laid out in the will. Unfortunately, that's complete fiction. That's not what happens here in the US. The process is exactly the same as whether you have a will or you don't have a will. The probate court still has to get involved. Everything is still public, which is why whenever most celebrities pass away, not all, but whenever most of them pass away, you hear about all their dirty laundry. You hear about who's getting the assets, who got cut out, what their estate's worth. That's because they're having to go through probate because they think, oh, I did the will and I'm good, right? I mean, for example, you guys can look this up. Look up Paul Walker's estate and you'll find out that his estate was worth $8 million, that he signed his will 8 years before he died, and that he left everything to his minor daughter, which means the court was actually controlling everything until she turned 18. Now, the reason why they know all this is because they went running into the courthouse. It's all public. So they can get a copy of the will itself. That's how come they knew exactly when he signed it. The assets are still frozen. This process isn't any shorter. It still costs the same amount. Now, people think, well, then what's the benefit of the will? The will, at least you're making a recommendation where you want your assets to go when probate finishes. Now, I'm using the term recommendation very specifically here because, again, if you're having to go through probate, anybody can fight over the assets. So it might not go according to what you laid out in the will, particularly if somebody's successful in that challenge. Now, the will not make it so that you only have one probate if you have assets outside the state of California. You just have to file that will in multiple states. So you still have the same issue with that. If you have minor beneficiaries, the guardian you name does not necessarily control those assets for the minor children. You still have to go through this probate process and designate who's managing those assets. Now, whoever that is now free to do whatever they want with the assets. The court's going to supervise them because those assets still cannot be touched for the minor children, generally speaking. Can we go to the next slide? Now, if you're having to go through this probate process, whether you have a will or you don't, now most of you guys are property owners, and you probably have mortgages on those. What happens if you have debt? Well, if you're having to go through probate, if you have debt, all those creditors have to be paid in full first. Now, the list of priority on who receives your assets through this process is going to be the debt creditors, the IRS, the courts, the attorneys, credit card debts, any unpaid medical bills, and anybody else that thinks you owe them money in their lifetime. Did you know that the last people to receive anything out of this process are the people you most want? Your beneficiaries and heirs are the last people to receive anything out of this process. Okay, go to the next slide. So what are your options to avoid that probate process? That would be the living trust document. Now, this only works if it's set up properly and you maintain it properly during your lifetime. And the process, as you notice, is almost the direct opposite. You don't have to go to probate court. Since it's not going through any court proceeding, everything stays private, generally speaking, with trust. They won't know the specific terms of your trust or whatnot unless you told them yourself. The assets don't become frozen because it's not stuck in the court where anybody has the authority to freeze it. And so you can transfer this instantly upon that. Since there's no probate process, you actually don't incur that expense and you can have full control over where your assets will end up. Okay, so that's why the living trust document is absolutely necessary for anybody who has minor children, owns businesses, or owns real estate. Now, that is the three, and that covers almost everybody around. There's very few people where they can avoid probate, and that would be you don't have any minor children, you don't own any real estate, and all your assets are basically on financial accounts that you can put beneficiaries on. Now, so for bank accounts, retirement accounts, investment accounts, you can actually put beneficiaries on all of those. Most people don't seem to understand you can do that even with bank accounts. And if you do, so long as the beneficiary survives and is not a minor, it'll automatically go to that beneficiary listed without probate court's involvement. But if any of those beneficiaries listed are minor children, they don't get it. You have to go through probate and it gets stuck with the court until they turn 18. Go to the next slide. Now, there are some people, I'm sure you might have met some people who did this, or you're thinking of doing this. They go, you know what? I can avoid probate. I'll just put all my assets in my children's name now. You know, it's a shortcut. It's inexpensive. It's simple. The problem with that is you lose complete control over your own property. Okay. For example, what if that child that you've just transferred all the assets to, unfortunately passes away before you do? The assets won't come back to you. In fact, we had this happen to a father who came running into our office trying to have the property put back in his own name after his son died. He had put the property in his son's name. The problem was he had nothing, no paperwork, because they didn't want to leave that paper trail showing that he was the one who was paying for this. And so we're not going to be able to get it back to him. The other issue is that property now is going to the minor child of that son. So his minor grandchild. So it's stuck in it's going to be stuck in probate. And so to do anything with that, the court has to approve it. Now, what about the biggest concern for a lot of people? What if their child divorces after you put the asset in their name? We actually also had this happen recently. A mother came in after her son divorced. The problem was she put the assets in her son's name, thinking, okay, I can avoid probate and whatnot. For 10 years, it was fine. But then the son got a divorce, and the court unfortunately awarded that home that the mother was living in to the son's ex-wife. As soon as the ex-wife got it, guess what she did? Kicked the mother out. So you can see the dangers of this. Now, there's also lawsuits. If your son or the child gets into a lawsuit, they may end up losing it in their lawsuits. The other issue with doing this is you've just shifted a huge capital gains tax burden on your children by shifting the assets to your children's name now. Because if you do it properly, like if it went through a will or no will, or if you do it in the trust, certain types of trust, you can actually minimize or even avoid that capital gains tax for your children because they would get a stepped up tax basis for that. The other issue is they might be forced to use it all up. For a lot of parents who are thinking of doing this, guess at what age they're doing this oftentimes? When they're close to retirement or retired. Where are a lot of grandchildren's age group generally? They might be in high school or maybe just starting college or whatnot. By shifting all the assets into the children's name, guess what they did? They just might have disqualified their grandchild from getting financial aid for their college education. Because generally speaking, for most of them, whose assets are considered for financial aid? Their parents. All of a sudden, their parents have this huge influx of wealth and assets. And so when you apply and that gets all reported, they no longer qualify. So what do the children have to do at that point when you shifted it? They end up having to go access some of that asset to pay for the grandchild's college education. They don't have a choice. So this is not a recommended method because you lose control. Next slide. Now, there are different types of trust you can do. And unfortunately, sometimes our own family member unintentionally ends up taking away the assets. For example, what happens if the surviving spouse remarries after the death of the first spouse? We hear this all the time. The children from that first marriage end up being disinherited when that new spouse comes into the picture. And so there are different types of trust you can set up to try and protect the assets even for your children so that they can't lose it to their bankruptcy, divorce, or whatnot. Go to the next slide. Okay, so as I said, there are different types of trust you can do. Now, testamentary trust that's on top, that's a trust you create in your will, last will and testament. But if you do a testamentary trust, the problem with that is you end up having to go to probate first, and whatever is left after the probate goes into this trust. The living trust is something you set up during your own lifetime. Now, there are two different broad categories that you can divide it up. And within each of these, there are also multiple ones. There's a revocable trust, and then there's the irrevocable trust. Now, the revocable trust is usually the most popular one, and that's to avoid probate. The irrevocable trust, there might be different purposes for it. For example, if for some of you who might have a lot of real property and your estate's now going to be over $10 million, that might be something you might need to consider because the US government has an estate tax. If you currently, that exemption amount is about 13 million. However, That's set to drop down to between 5 and 6 million on January 1st, 2026. So if you pass away after January 1st, 2026, and if you're married, it'll be about 10 million that you can pass to your children. If you're not, it'll be about 5 million. And you have assets above that threshold, anything above it, the US government will tax your estate 40%, 40. So the first dollar over it, the US government will take 40 cents. It's not like it graduates. It's automatically anything above that exemption amount is gonna be taxed at 40%. So there's a very specific type of trust, irrevocable, where you can try and minimize or avoid those estate tax. Now, here's the bigger kicker most people don't seem to understand. When it comes to estate taxes, if you have life insurance, the death benefits are included as part of your estate. So if you have $10 million in estate, life insurance death benefits, you automatically are going to get stuck right in that estate tax threshold area. Okay. Now, the asset protection trust is a different type of irrevocable trust that you can use to try and protect the assets from your own lawsuits, creditors, or whatnot. But for that type of trust, there are some restrictions that are placed on you. For example, by doing that type of trust, you're actually giving up all of your own access during your own lifetime to any of the principal in there and only reserving for yourself the income. Okay. But whatever is in there, so for that type of trust, the asset has to be fully paid for because lenders will not allow you to put it in there. Because if you're giving up access, they'll have a very difficult time going after it if you default on the loan. So it can't be used as a collateral, but for the assets that are fully paid for, you can put in this type of trust so that even if you get sued, at least that asset, the principal itself, cannot be lost in that lawsuit. I'll go to the next slide. So I put up something that talks about the different types of trust. Now the irrevocable, I split into that too, asset protection side and the irrevocable. Now the revocable, as I said, is the most popular. For that type of trust, you are the trustee, so you manage everything you put in it. And for revocable, you have to think of it more like a DBA, since you guys are very business savvy, because during your own lifetime, there's no real separation from you. The law still views it as your own asset or whatnot, even though the asset's listed under the trust name. You have full control, you can use it all up, you have full access. This type of trust, you can make whatever changes to it at any time, and even completely get rid of it. Now, as I said, the tax avoidance trust one though, keep in mind, you have to think of it like you're giving away the asset now, because it's more like a corporation. It's a completely separate entity from you, and you actually can't even control it. So you cannot be trustee. You don't have any use or access to any of the assets. You can't terminate or change anything in this. And for this particular one, you actually have to go get a separate tax ID and file tax returns for it every year. As I said, it's like a completely separate entity from you. You have to think of it like you don't own the assets you put in that trust anymore. Now, the one that's in the middle, for the asset protection, that one is a little different in that you can be the trustee, but you generally have to have a co-trustee, somebody else to help you manage the assets. So you lose a little control, but you still maintain a bulk of it, and you can use the income. You just can't use the principal. That's why it's indirect access. You can make certain amendments to this. You can amend who the beneficiaries are, and you can amend who the trustees are, but that's about it for amendments. But since you're retaining all rights to all the income, you don't actually get a separate tax ID and file separate tax returns for that. So the next slide. Now, here's another key point to keep in mind. I know some of you guys had said you guys are doing your own or doing a trust right now or whatnot. Now, I don't know who the trust attorneys are, but I've seen this happen a lot. Either they go online to LegalZoom, or they do something with some attorney that they found on the billboard who does personal injury and all these other things, and then says wills and trust. When you set up the trust, when you have that document, you sign it, that document by itself is actually meaningless until you integrate all the assets with the trust. So by that, I mean, you have to make certain that all your assets are somehow tied with it. So like for real property and for LLCs and businesses, you actually have to transfer the ownership so that the trust is now listed as the owner. For financial accounts, you don't actually have to have the trust be the owner now. For like most trusts, you actually just make the trust the beneficiary, so it flows through your trust and goes to the people as you stated in that document. But you have to properly tie the assets. And we have a lot of clients coming into us who did a trust with somebody else. And when we ask them the first thing, what does a trust own? They are like completely confused. They don't even know what that means. I'm all, okay, whose name is real property listed on there? They go, my name. So what they did was they signed this document. They paid however much they paid, $1,000, $2,000, $3,000, $4,000. And that document is because the trust doesn't control anything. And for most people though, they never find out that it wasn't done, it wasn't completed. Because to complete this process, you have to integrate the asset. Most people never find out. It's their family members who find out after their death when they get stuck in probate, even though they did a trust.
So Hee Jae, to interrupt, like a good way to find out, like for all the realtors on the call, when we're looking at title, it will say that it's in a trust. If it doesn't, and the family says, oh, no, this is our property's in a trust, but title doesn't say it's in a trust, can it still be in a trust? Or is that a mistake that they made?
That is a mistake that they made. They forgot to properly fund the trust, which means that asset is sitting outside the trust at the time of death to even move it. And if you did a living trust properly, you should at least have a pour over will, which says it'll go into the trust, but that requires that property to still go through the probate process and then get poured into the trust. So that does simplify probate a little bit, but it still requires probate. That's not something you want to go through. So you have to make certain it's properly funded.
There's one thing that we come across, which is when people refinance and their lender requires them to take the property out of their trust and they don't put it back into the trust. And that happens, and that's a problem.
So I've seen that happen.
Right.
But I've seen lenders treat this differently. Okay. I had some clients where the lender says, you have to take it out of the trust and we can do that for you so that to refinance. And some of these lenders will help them actually do the new deed to take it out of the trust, do the refinancing. And some lenders, not all, will then, after everything's said and done, prepare a new deed and put it back in the trust for this. But that doesn't happen often. A lot of them will say, we'll do the deed to take it out of the trust so we can refinance because they want the business, but then they don't go back and put it back in. But
Most people don't even think about it.
Well, they don't
I didn't
know.
think about it, yeah.
They don't
Yeah.
know.
They don't know. And so that's what
I
usually.
guess because I refinanced before I put my property in a trust. So I was part of that.
Okay, so we're gonna- next slide. I think this is more for a lot of the business. So there are some of you that might have asked your property in like LLCs. Now, assuming if you have questions about what I'm talking about here, schedule that consult and I'll explain it in a little more detail. Assuming you kept the corporate formalities, you created a bubble around that property. So any lawsuit that arises within that bubble stays within that bubble. Anything outside of it is outside, so they can't go after anything outside the bubble. Now, if you have certain types of trust, the irrevocable ones, you can actually create a shell around everything else too. So you have that bubble of your corporate property, and then if you do that one of those irrevocable trusts, you can actually put a shell around your other properties so that you can't lose it in other lawsuits. Now, when we say bubble, so when you look at the client world, if they get into a car accident, since that's outside the bubble, they can go after everything that the client owns. However, if it's in the asset protection trust, since you've given up access to the principal itself, that stays protected. Okay, so there are different ways you can try and protect the assets from your own sort of like lawsuits and life events. LLCs is a great way. Now in California though, so I will get into Prop 19 a little bit. If you're moving assets into an irrevocable trust, since you've actually given up access to the principal and you've named other people as the principal beneficiary during your own lifetime, it does trigger some Prop 19 tax consequences as to that, because the law views that kind of change where you go from yourself as the owner to an irrevocable trust where you're not the primary beneficiary during your lifetime as a change in ownership that triggers a reassessment of the property values for property tax assessment. So if you're going to do this type of trust in California, that is something you have to weigh. So there's pros and cons to trying to do something like this, okay, for the irrevocable trust. I think that's about it. Okay, so those are some of the risks if you don't plan. Now, even with the revocable, we do two different types. One of them is set up so that it can protect the assets your children receive from their lawsuits, from their divorces and whatnot. Okay, so the most basic ones will not, generally speaking. Next slide. I think that's it. Okay, so if you're gonna just do a will, please customize it. And if you're gonna do a trust, as I said, make certain you integrate all your assets with that trust. Because if you don't, that trust is meaningless. And I think last slide. Now, whatever you do, this is important. Just because you did your estate planning, that doesn't mean you're all set. You got to review it and properly maintain it during your lifetime. Okay. For example, your family dynamics might change. For some of you, you might be having new children. And if you've completely cut them out, it might mess up the plan that you are thinking. Some of you, your financial situation might change. Right now, you might not be facing an estate tax issue, but later you might be. So you might have to do some sort of more advanced type of estate planning. The health might change, so maybe you might have to do something for long-term care. And even the laws change, actually, when it comes to estate plans. I actually talked about one of those already when it comes to the estate tax that is going to drop down. Okay, so review it regularly and just make certain it stays up to date and it continues to meet your needs and concerns. Okay.
Is that something you do, Hee Jae, as one of your consults? If someone has something set up, review what they have, or?
Yes. So for the free consult that I'm offering, if you guys already have something in place, and I've had this happen a lot, and you want that explained to you, just schedule that consult, email me those documents so I can review it, and I will explain what it does. Oftentimes we have clients come in who's done a trust and they don't know what their trust is going to do. And when we ask them, how come you don't know what your trust is going to do? We find, particularly for those who do, like, you know, who found someone on the billboard, what we found was they meet with the attorney first just to see whether they want to go with him. They agree to go with him. They meet him one more time to discuss how they want their plan set up. And then the couple of weeks to a couple of months later, the attorney calls them in, has them sign a bunch of papers without ever explaining what those papers are. It's like, this is your trust, without explaining what it does. And so if you already did something and you don't know what it's going to do, you can schedule that consult and I will actually explain what your trust is going to do. And if it doesn't meet your needs, you can, assuming it's revocable at least, you can redo it. Okay.
Yeah, I think, I mean, I know from a lot of my clients in the past that their hesitation in setting up a trust is that it's such a final decision. It feels like to go through that process, but they don't realize that it can and probably should be changed at some point as the years goes on. So you can't really, you know, make that mistake that you're afraid of. You can always go back if it's a revocable trust and keep editing that and changing it to fit what your real wishes are. So thank you very much. That was very, very informative. And again, this is recorded, so go back to our YouTube page at the Collective Realty and search our multifamily sources. And if you want to share this video with anyone, you can. I also brought on someone from WFG Title, Ms. Ernie, who's here to talk to us about, in the real world, what do we see through properties and title that can be issues or concerns, you know, when a trust is held as.
Right. Well, you know, I think you did such a fabulous job. And
Can you point the microphone to you?
Yeah, we can't hear very well.
is this good? Better?
Yes, that's
Better.
better.
Okay. I'm not used to this celebrity kind of stuff. But we do see a lot of the situations arise that you described. And I don't really have a presentation, and our situation at the title company, we're mostly dealing with properties that are already vested in a trust, or maybe not, people thought they were vested in a trust. So we're getting the transactions and we're looking at it from the seller's point of view. Whereas I feel like this is more directed towards how, you know, how will you own it? But from a seller's point of view, what's important, and I did say, let's ask this question, is it important that the trustees of the trust be named on the deed? And that's a document that transfers the property into the trust? And the answer to that is yes. A lot of times we'll see people take title as Bob Smith Trust. That's nothing. That doesn't even really transfer title. That could be considered a flaw, and that's a problem. Most title companies will try to help to work around that by, trying to verify that we're dealing with the right trust, but Bob Smith Trust isn't really describing anything. I also wanted to talk about a common misconception that a trust is a shield from your creditors. It can be, but it's not always. So we talked about revocable trust is not a shield from your creditor. So people might say, I have my property in the trust, so why is this judgment attaching to the property? It does. If it's against you, the beneficiary, and trustee of the trust, the trustor, it is going to attach to the property. Okay, that's just a common misconception. When the property is vested in a trust, and the property goes to sell, there's going to be title company requirements. If we see that the original trustee is the one selling, the person who conveyed it into their trust, or maybe they bought it as, into their trust, and it's the original person, we only need a trust cert. There's a trust certification form that we can take. If we are now dealing with the successor trustee, that means the original trustee has passed away. We like to ask for a full copy of the trust. And we do keep it confidential. It's not like it's going public. It's nothing like that. But we want to see who the successor trustee is. Without a copy of the trust, anybody could tell us they're the successor trustee. So we want to make sure before we insure the property, we want to see who was named on the trust. We also would have a copy of the death cert because we want to make sure, or find out what happened. Why isn't the original trustee acting? We've had cases where, I think like you said, properties, sometimes people live in them and people die and nothing happens for many, many, many years. And then all of a sudden they go to sell the property, the heir does, or maybe they themselves die. And now here we are. And we find out maybe there is a property vested in a trust and the successor trustee can't find a copy. And it's been 20, 25 years that they don't have a copy. That's a problem. Because we at the title company, we don't know if this person is really the successor trustee without that trust. So it's very important to keep copies of these things and know where they are, because you may have to supply them. Okay.
So, question, what if, this has come up with me in the past where a client is like, I don't know where our trust is, but it says that I am trustee of this trust, but I don't have a copy of my trust. What are some strategies that you tell your clients to do with the trust? Like, for example, mine is in a folder in my house. My estate planning attorney has it, and my family law attorney has it. But safety deposit box, then you need to make sure someone has the key to that. Who is that? Like, what's the best system that people use to keep it safe and make sure that somebody knows where it is and how to find it?
I can tell you how.
Because they're not recorded. People think that trusts are recorded and you could just search the county and find it, and it's not true. The deed is recorded for a property, but not the entire trust.
I can tell you how our firm actually handles that. We actually send or give the clients back the originals in nice little binders. So they don't have to go get their own binders with all their important documents in there. We actually scan a copy. We actually keep a physical copy at our headquarters in Atlanta for our records. And we also actually scan. So we have both the physical copy and an electronic copy at the firm. And we actually email a copy of that electronic version to the client. So the client can send it to whoever they want or store it somewhere safe. And if they, for any of our clients who sign up, we actually tell them, you can tell your, if you don't want to show them the terms of your trust, you just tell them who to contact. And for our clients, we actually offer them a free consult with their beneficiaries or successor trustees or whatnot to answer any questions or give them any instructions. And so they can just contact us and we can actually, as long as they can prove to us they're the person named as a successor trustee or beneficiary to, so they have driver's license or some form of identification, we will actually pull up those trusts and we actually have a copy, both electronically as well as physical copy. And for trust, copies are just as good as originals. I can't say the same for wills because a lot of places require that the original will be filed with the probate court. And so if you go to a estate planning attorney and they hold on to your original, that's usually not a good sign. Because if they're holding on to the original, what they're saying is, I'm requiring you or your family members to come back to my office so that I get the first shot at taking that probate. Okay, so you for wills, the originals are very important. For trust, electronic copies or other copies are just as good as the original. And so we actually keep both copies, both a physical and electronic copy. We actually send the client both copies. And so there's multiple ways that it can be found.
I think also I remember one situation I was in where a child who they believed they were the beneficiary of their parents' trust had no record of the trust. The parents had passed away, had no record of it. We had to figure out where could we find this trust. So we looked for, we did figure out who the attorney was. The attorney was passed away. And there was no record there. And then Zoe, I think you recommended, we'll check the bank accounts. Sometimes the banks might have a copy of it. And one of the banks did. And that was kind of the way to save them. But if they didn't have that bank account and the attorney had passed away because for whatever reason, you got to have a system to save that trust and make sure that your beneficiaries do. And so I know that some clients, they don't even want to let their people know that they're a beneficiary. So you can't always tell them and prep them. It's tricky. So you got to figure out what's your system going to be. Yeah.
And you probably really need to let them know, your beneficiaries, where this is, right? Where to find it. That's also important. But we can rely on an attorney's letter if a person doesn't have the trust or they don't want to send it. We will take something from their attorney saying, this is the, telling us what we need to know. We can accept that. Another common misconception is that an attorney, in fact, cannot sign for the trustee of the trust, not unless there's provisions in the trust that provide for that. And I do see it a lot more now. So I'm old and I've been doing this a long time, but we never saw that provision before, but we are starting to see it more and more because a lot of times people, maybe they're traveling or they're out of the country, their property's vested in a trust, they're selling the property and they say, I'm going to give a power of attorney. And we say, well, what does your trust say? Does your trust say that you can appoint an agent to act on your behalf? So we will need to read the trust to make that determination to see if we can accept that. And then I have down, let's see the other questions. Okay. The other matters that we have to consider, because we're trying to protect people. We're looking at things that happen, that we see happen all the time. We do see a lot of elder abuse, and that is such a problem. There is a lot of abuse with power of attorneys, that is true, but there also is with trust, and we see people amending people's trust when they're old. So we're very careful when we start seeing amendments. We want to make sure the person, that original trustor or trustee, was the person who made these amendments. And then we get very careful when we start seeing people being disowned and all these different things happening and change of trustee. And we try to be very careful. So those are the kinds of things that we look for, because any situation, I guess, can be taken advantage of. Like we talk about wills in court, but also trust they can also, and that's why I think you're right. It's good to have it reviewed periodically. And if you have this connection with your attorney, that's going to help a lot, because we can rely on the attorney. Okay. And so I think we're really talking mostly about trust. There's many other ways to hold title, right? With joint tenancy, community property, you mentioned all those before. and it's really important to know how you hold title. I just want to bring up one thing. I don't know if you'll find it interesting or not, but we did have a challenging file where we had 5 siblings on title as joint tenants. And they started to pass away and they never recorded their affidavit death of joint tenant. And it was such a challenge to get to the point, but one of the siblings came off a title and deeded it to the remaining 3, but did not put as joint tenants. So what happened is that as they died, only the part that remained in joint tenancy passed to the surviving joint tenant. The part and the tenancy in common had to go to probate. And it was a really challenging situation because nobody knew that this was a problem. So I'm just bringing that's the kind of things that we'll see. So it's important to look at how do you hold title so that you can be prepared or help or be prepared.
I think I have one question online and then we can get back to anything else. I have one question too, actually 2 questions. Patricia, go ahead.
Yeah, so just a clarification, if a property is held as tenants in common, does it always go to probate even if it's in a trust?
Well, it won't be tenants in common if it's in a trust.
Okay, and so
tenants in common would be between individuals. You could have like a trust as to an undivided 50% interest and then marry as to an undivided 50% interest. And that's really a tenancy in common. Tenancy in common just means each their own way, so that's to their own heirs.
But if it was in a trust and if it was worded like that, it wouldn't go to probate.
So if it was, oh, are you saying if the beneficiaries of the trust that they are tenants in common when the original trustor passes away?
The property and it's actually owned by 2 people who are not married. Maybe I'm making this more complicated than it is. Would it be a tenant and they each have their own trust?
Can I address this question because I'm actually in this right now?
Okay.
So I actually own a property with partners, and my portion of our ownership, we own 50%, is in our trust. My wife and I have a trust, and so we own our piece of it in a trust. The other 2 partners who each own 25% own it in their individual names.
Okay.
Okay. So I think the answer is like, obviously, if one of them passes, that's the question, I think, right? Is like, if one of them passes and they haven't put their individual, their piece of the tenancy in common into a trust or whatnot, does their piece of it go into probate? I don't know.
Yes.
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 If you don't, if you don't do it, as I said, it complicates and it's going to make the probate more expensive later because for that person's assets, it should have gone into probate usually within a short frame of time after their death. Because everything has to be accounted for. Because if they had debt or whatnot, they need to go and collect all those assets to see what can be paid out. And so if it's not, and you wait years, that's going to make the probate much more expensive because now you have to hire more forensic accountants and everybody, more specialists, just to backtrack everything to clear title and true ownership of that property. Now, in Patricia's situation, when she talks about 2 different people who own the property, but they each own it in their separate trust, assuming that it's really titled in those 2 separate trusts, while it is still tenants in common, it won't have to go through probate because each person's respective shares will pass through their trust.
Right.
Okay.
And so a person does not have to, is not limited to just a single trust. I've had some people who have more than 1 trust. I actually have a family, that's clients, 3 siblings. They each did their own trust with their spouses. And then they have a joint trust between the three of them because before they got married, they had invested in a couple properties together where they were the three owners. And so they kept that separate. And so they wanted to do something so that that can also be passed to their respective beneficiaries. And they didn't want to complicate things since it's, that's sort of a separate issue. So they've done a joint trust between the three of them as to what happens to those couple properties that they own together.
So let me complicate this even a little further, because in our case, we've already deeded the property into the LLC. And we each own, like I said, our trust owns 50% of the LLC and the other two own their 25% in their individual names. So would that, obviously the LLC is for the property, but like if one of them passes, would then the probate be for, it would just be for their part of the LLC. It wouldn't be for the property necessarily, would it?
It won't be for the property, it will be for the LLC, but then.
Who's the manager?
It was the manager, but here's the other issue with the it being stuck in LLC. Even if you're the manager, if it has a significant effect on the valuation of the LLC, it may require the court's approval for that business transaction. Because you're affecting the 25% interest that might be passing through probate. As I said, that 25% is frozen with the probate court. So if it's going to have a huge effect on the valuation, it may require the court's approval for that 25%, or the manager might be liable if that value decreases because they did something without the court's approval. Now, that's why most businesses that get stuck in probate generally do not survive that process, because the courts aren't the quickest to act and it's a long process.
We've had cases where LLCs are on title and one of the members say is deceased, and they say, well, now don't the other members sign? No, because they don't just automatically get control. They have to go to court and they have to get letters of administration. They have to start a probate process. And we need something from the courts in order to know who can sign on behalf of that interest in the LLC. And so that is going to cause a problem. You're right. That's a huge problem. We do see it.
Interesting. So everybody needs a trust, especially if you're buying real estate with someone else.
That's true.
Okay, interesting. So I guess, every time I hear about estate planning, there's always something new that pops out to me that I learn. And I really appreciate all of your insight. I know you mentioned that one big mistake that people make is that they're not putting their assets into the trust. So the trust isn't owning the assets like the business. So if you have a corporation, then the stock certificate needs to be owned by the trust. And I think some people maybe miss that. For a property, obviously the deed needs to become into the trust name. And that's something that, Zoe does and has helped our clients with. And you said bank accounts, sometimes they could be in the beneficiary. It's probably best if the beneficiary is the trust. But how about like crypto wallets and crypto accounts? I don't think there's any beneficiary that you name in those. How does that money get transferred? Does it just need to be named in the trust, like mentioned, or?
I don't know, because for some of them, you might still be able to do a transfer in that, because a lot of the investment. So when I say beneficiaries, I'm using that term because that's where it's going. But keep in mind, for these different types of accounts, what it's actually called depends on the type of account. For bank accounts, while I said you can put beneficiaries, the technical term for bank accounts would be a payable on death designation. Okay. For retirement accounts and investment accounts, generally it's called a transfer on death designation. And so if the crypto account actually has a TOD, you might want to ask, then that will suffice for it to flow. Now that's a new thing, and I don't know what the regulation is going to be like in the law, and so we'll just have to see as things change. But if it has a transfer on death, it'll flow automatically. Now, if it has nothing and it's purely digital, maybe, because, it's not, it might be something where if they have the right key, because that's how you get access to it.
The password and key, yeah.
then they might be the one that may be able to control it, but it's sort of not something that's a relatively new thing. So I don't really know the ins and outs of those accounts very well. So I can't really tell you for certain. But if it has a if you can do a TOD on it, that should pass without problem.
Okay. Any other final questions before we wrap up? Any other final comments or statements from our panel?
Question. I have a question.
Okay, go ahead and we'll get to you next.
What are the, do you also establish LLC?
We do as part of the estate planning, if that's something you want to do. And we do establish LLCs for clients as part of their estate plan. Now, if you're trying to move real properties into LLC, keep in mind, if it has a mortgage, it's gonna require the lender's approval.
Okay.
Because when you're moving it into an LLC, since that's considered a separate entity, the lenders consider that a transfer in ownership and that may trigger their acceleration clause.
Oh, okay. Thank you.
Question.
Okay, go ahead.
Oh, should, if something's a C corp, should that be in a trust? Because wouldn't it not be because it's its own entity?
It should be in the trust, right?
It should be in the trust because it's a business still, and so it doesn't transfer automatically upon your death. If the owner dies, where does it go? If it's not in a trust or controlled by the trust at the time of your death, it's gonna have to go through probate.
Definitely put your corporations in a trust.
Be the shares at that point, right?
So in an LLC, the issue becomes if the managing member is the one that is deceased, correct? So as long as somebody who owns shares of the LLC, they're not the managing member, then the managing member can still control the LLC, correct?
Well, I think you please correct me if I'm wrong, but if the LLC, if the operating agreement appoints a managing member, we're going to rely on that managing member that they have the ability to sign for the LLC, and the proceeds, let's just say this is a sale, are going to the LLC, and it's going to be up to the managing member to distribute. But how is the managing member going to distribute to the dead person, right? You know what I mean? So that's maybe where the issue comes in. Did you have another?
No, so
They distribute it.
No,
By the ownership of the LLC, right? So.
But one of the owners is dead, so where does it show go? That requires probate.
That requires probate. It'll go to the estate, right?
It has to be the estate of the person who's dead, and for people to be able to get access to that, that requires it goes to probate process. So it doesn't matter if the management. Now,
So any owner, even if they're not the managing member, their share of that goes through probate. Their share of the LLC.
Yes.
Yes.
The managing member can sign on behalf of the LLC, et cetera.
Well, the only things I've seen sometimes where they sort of avoid probate is.
Could you please repeat the question because we can't hear it from here? And please bring the microphone closer.
So because the property, if it's sold, the distribution has to go to someone who's passed away. Those assets still has to go through probate to see who that's going to get distributed to, since it goes to that person's estate. Now, the only time I've seen sort of avoidance of probate when it comes to these LLCs or whatnot, well, it's not really LLCs, not LLCs, partnerships, is when they have a specific agreement that upon the death of one of the partners, they can buy out the dead partner's share by paying the family, not the estate, by paying the surviving spouse and children. Now, assuming that there's no minor children, that, because of the agreement itself, the contractual agreement says, well, I get full ownership upon paying out the fair market value of the partnership. Now, that might require some appraisal or whatnot, assuming that that's done fairly and the family doesn't take them to court because it was undervalued. I've seen where they sort of avoid probate because there's already somewhere that the money's directed to go to and it's not to their estate.
All right. Well, this is a lot of great information. I'm gonna re-listen to this because when you were talking about some things, I was thinking about others, and it was a lot. So thank you guys all for being here. We'll be back again next month talking about ADUs and some updates to SB9. It's going to be a really great session. So I invite you to come back and check out our YouTube page at The Collective Realty, and we'll see you next time. Bye.
Okay, where can I find the recording? If you don't mind me asking.
What? I'm sorry.
Where can I find the recording?
It'll be loaded tomorrow on YouTube. So if you search The Collective Realty on YouTube, it will be on there on our page. And our past sessions are there too for you to see. Bye.
Everyone, and thank you guys so much for coming to speak. We really appreciate it.
Yes, the best. You guys are awesome.
Okay.
Good info.
Yeah.
That's good info. It's interesting because we kind of come at it from a different angle.
You're the
I'm not
kind of
a
ensure.
forensic person.
I'm trying to make it so that your
Right.
job
Yes,
is easy
right,
That's right.
exactly.
by having it planned properly.
That's right.
Oh,
Yeah.
there we go.
But you know, some of the problems you see, I've seen
Oh, yeah.
with
Yeah.
prior clients or